sa prosecution panel. So ito muna yung pakinggan natin itong may katanungan dito.
Two sentences, one sentence, and then no questions. Yeah, I know. Sadly, no? Sad. Siya ang may kasalanan. Sabi niya no questions daw.
Ma'am, over.
Yes. So, my statement is, in this bloodbath and bludgeoning, I will be blooded.
Anyway, after nito, yung yung impeachment, no, yung day 2 andyan lahat. Ipakita ko lang na talagang dumating siya, no. So mas maganda panoorin natin yung buo kasi ang dami nating makukuha diyan, ma-assess natin kung credible ba yung mga witness na magsalita. Ayan. Okay. Pakinggan natin si BP Sara na dumalo sa day 2.
But unbowed. Maraming salamat.
Ma'am, kamusta kayo, ma'am?
Ang tipid. Ang tipid. Teka, pakinggan na. Ang tipid ng sinabi.
Dito tayo, dumating siya dito kasama.
Teka, saglit lang ha. Ito. Ang tipid
ng
talaga eh. Pero marami yung
si Vice President.
yung dito Dami tayong matutunghayan diyan.
Mismo, no? So, tinanong natin, trinay natin, although bawal yung motion
natin.
to set up.
Okay. Just two sentences, one sentence, and then no questions.
Pinagbigyan lang.
I know. Sadly, no? Sad. Siya ang may kasalanan. Sabi niya no questions daw.
Ma'am, over.
Sad.
Yes. So, my statement is, in this bloodbath and bludgeoning, I will be blooded but unbowed. Maraming salamat.
Ma'am, kamusta kayo, ma'am?
Anyway, doon na tayo sa sa impeachment. Shout out po, comment lang po diyan. Medyo mahaba-haba ito pero maraming mahalagang bagay ng mga presentation of witnesses and may mga cross-examine and magsasalita din po yung mga senators, judges, no? So dito tayo banda. And comment
Senator
lang
Judge
po. Don't forget paki-like po itong video natin.
For Erwin.
Live.
Senator Judge Tulfo Rafi, Senator Judge Villanueva, Senator Judge Villar Camille, Senator Judge Villar Mark, Senator Judge Zubiri, the presiding officer, Senator Judge Escudero, the Senate President.
20 senators present, the chair declares the presence of a quorum. We now recognize the presiding officer, Senator Chis Escudero.
Thank you, Mr. Senate President. The reading of the Journal of July 6, 2026 of the Senate sitting as...
Ito, mamasingit ko lang. Ito yung first time in the history na may Senate President at may presiding judge na nakaupo sa harap na magkatabi. No? First time in history. Take note. Sa rules kasi ng Senate rules, ang Senate President, siya sana ang tatayong presiding judge. Pero bakit? Ang tanong, bakit? Malamang hindi attorney si Senator Sherwin Gatchalian na siya yung Senate President ngayon. And baka hindi pa masyadong hilaw pa, kumbaga. So, kailangan ng mas knowledgeable and experience si Senator Chis. Sabi nga ni Senator Robin, bakit hindi na lang gawing Senate President itong si Chis Escudero? Total, siya naman ang presiding judge para isang uupo. Okay, comment lang po kayo kung anong masasabi niyo dyan. Tuloy po tayo dito sa
An impeachment court is hereby dispensed with, and unless there are any objections, the same is hereby approved and adopted. The clerk of court will now please read and call the case before this impeachment court.
Case number 004-2026 in the matter of impeachment trial of Vice President Sara Duterte.
Appearances.
Good afternoon, Your Honors. Same appearance for the prosecution. We are ready, Your Honor.
Noted. Appearances for the respondent.
Good morning, Your Honor. Same appearances for the defense.
Is the prosecution ready to call its first witness?
Yes, Your Honor. However, the prosecution have few concerns which it wanted to raise before the Honorable Impeachment Court. So may I request, Your Honor, that the Honorable Counsel for the Prosecutor, Lorna P. Kapunan, be recognized, Your Honor.
Before recognizing the counsel for the prosecutor, ma'am, upo muna kayo. Chair would like to recognize first Senator Judge Lacson. What is the pleasure of the Honorable Lacson?
It's a point of inquiry, Mr.
You may proceed, sir.
Yes, Mr. Senate President, Mr. Presiding Officer, Your Honors. Just so it will be clear to our fellow Senator judges, as well as the panel of prosecutors, the defense team, and the public in general, yesterday after your election as presiding officer, you delivered your opening statement, portions of which I will either quote or paraphrase as follows. You stated, the Constitution states that conviction can only happen with the concurrence of 2/3 of all members of the Senate. And then you continued, with 24 members of the Senate, a literal interpretation of this means that conviction requires the affirmative vote of at least 16 senator judges. However, you also made it clear that, and I quote, those who disagree have the right to go about it through a legal challenge, and should the Supreme Court, by virtue of its power of judicial review, render a different ruling on this question, the impeachment court shall faithfully abide by that ruling, unquote. My point of inquiry, Mr. President, Mr. Presiding Officer, is this portion of your opening statement a matter of legal opinion on your part as presiding officer, or does it constitute a ruling by the impeachment court? If the response is, it is the latter, does this mean that this court, through the presiding officer, has raised the level of discourse to a justiciable issue or a dispute that the Supreme Court may have legal authority to settle and resolve? In case either one or both panels in front of us decide to exercise their right to challenge the said ruling, should they deem it as a grave abuse of discretion by this court? I submit, Your Honor.
The response of the presiding officer is in fact, the journal that we just approved contains a similar inquiry by Senator Judge Cayetano yesterday, when he inquired if it was the position and ruling of the presiding officer, and the presiding officer answered in the affirmative. So to clarify, yes, I believe it may be considered already as a justiciable controversy, although it is not for us to dictate that, but the courts, given that it is a ruling of the chair not objected to nor appealed by any member of this court, and therefore stands.
Thank you for the clarification, Mr. Presiding Officer.
Thank you, Senator Judge Lacson. Senator Judge Cayetano, what is your pleasure, sir?
Sir President, Presiding Officer, may I just further clarify this statement?
You may proceed, sir.
Yes. I confirm that yesterday we heard the same thing, and when the transcripts come out, of course, then it will be available to everyone. Basically, yesterday I clarified whether that was the opinion of the elected presiding officer, and of course, without any offense to my brother and friend, Senator Escudero, we have a continuing objection. I asked him whether this was already a ruling of the court, because if it's the ruling of the court, then as a threshold issue, we will have no further questions. Section 22, Article 22 of our rule says that all orders, decisions may be acted upon without objection, or if objection is heard, the orders and decisions shall be voted on without debate by ayes and nays, which shall be entered in the record. subject, however, to operation of Rule 6, and Rule 6 speaks of whether the presiding officer will rule on relevance, admissibility, and giving any movant 2 minutes. So I may also correct that yesterday I was not allowed to, when I objected to Senator Lacson, I should have been given 10 minutes in accordance with Section 22. But I do admit that before that, in the point of order, Senate President Gatchalian was liberal in allowing us to explain. Anyway, everything has been explained yesterday as the constitutional issue of the presiding officer, and since you allowed us to submit in writing, we will do so. But just on this point of the threshold issue of 2/3 of all members, there is actually a pending case in the Supreme Court entitled Cayetano versus Aquino. That is myself and my seatmate, Senator Aquino. We talked, but we're not talking about the case. So actually, you're correct, Senator Lacson, that anyone can go on this issue itself. And I just like to make sure today and further clarify that there's no objections that as of today, the stand of the impeachment court is that of all members means that as long as you're still a member, so meaning when are you not a member anymore? When you die, when you are removed by finality, and when you resign. No? Otherwise, you are still a member, so you are still counted. And it is in that spirit that we ask, and we're preparing maybe a memoranda for all members to allow Senator Marcoleta and Senator Jinggoy, since they are going to have a vote. And if they vote, then that will be counted as a vote for ako. And that might be favorable to the defense rather than a part of giving a fair trial. So all I wanted to clarify today, Mr. President, is that we will continue to trash out if there are any concerns of today. It is very clear that as a court, we have decided that 2/3 of 24, there are 24 members of the Senate today, 20 are present here today, but there are still 24 members, and 16 ang number of senators needed to convict on any of the articles, Mr. President, Mr. Presiding Officer. Thank you.
What is the pleasure of Senator Judge Pangilinan?
21 na pala.
Thank you, Mr. Presiding Officer, Mr. Senate President. Just to place on record that I would like to clarify that the ruling of the chair of 16 is as to the issue of whether the threshold number of conviction. The matter of whether or not Senators Marcoleta and Senator Estrada should be participating in the process of the trial is another matter that we will have to discuss perhaps in camera or on the floor at a later date, Mr. President.
Noted. If there are no other senator judge who wishes to make a manifestation, the lead prosecutor, Representative Luistro, is once again recognized. What was your earlier manifestation and motion, ma'am?
Your Honor, we respectfully reiterate our request that counsel for the panel of prosecutors, Attorney Lorna Capunan, be recognized.
Counsel for the panel of prosecutors, Attorney Lorna Capunan, is recognized. Will you be the one to present your first witness, ma'am?
Good afternoon, Your Honors, Senate President, Presiding Justice. I do have manifestation. Well, in direct answer to the query of the presiding Senator Judge, I am not presenting the witness today. But I would like, with your permission, Your Honors, to manifest a query that we request be addressed by this honorable court, presiding judge, to the defense.
The lady may proceed.
We are informed, and in fact, we have seen an interview conducted in the Senate premises on the Vice President herself. And she had been quoted as saying that she is expecting a bloodbath and a bludgeoning, but she will not, her head may be blooded but unbowed. My respectful query, Your Honors, please, which could be directed to the defense counsels, is if the Vice President is in the premises, does she intend to appear personally before this impeachment court? And that is preliminary to another manifestation that I would like to make. Your
Kindly
Honors, please.
proceed with your next one, Counsel. Because the chair is not yet sure if it will even address this to the Counsel for Respondents or will simply answer the query of the Counsel for Respondents.
This is relevant to the presentation that we will be making this afternoon, Your Honors. This court will recall your own statements, Mr. Presiding Judge, that on Tuesdays, every Tuesday of every week, that the prosecution must indicate who the witnesses they intend to present before this court will be. This is to enable the impeachment court to issue, when appropriate, and if deemed necessary, a subpoena for such witness. And that is my query this afternoon, because an presentation of witness on the first article that we will be presenting, which is grave threats and acts of sedition, Your Honor. One of the key witnesses, hostile, albeit hostile, would be the Vice President. And therefore, if we can inquire if it is her intention to again appear in the premises of the Senate, because we are already respectfully informing this honorable court that we will manifest, that we will have a written request for her presence in connection with this article on grave threats. Your Honor, that is the relevancy of my manifestation.
The chair would like to rule on the manifestation and request of the Counsel for Prosecutors instead of throwing the question to the Counsel for Respondents, for the simple reason that I do not want to, the parties to engage in a debate before this court. You can very well do that with the presentation of your witness through direct and cross-examination, redirect and recross. To answer, the impeachment rules do not mandate nor require the respondent to attend any hearing or trial of the impeachment court. Whether she was in the building earlier or arrived after, it is totally up to the respondent, because from the point of view of the court, she is represented in this court through her counsel already. Should the counsel for the prosecutors desire to call the respondent herself, the court will act on that motion and request once it is made and or filed, and need not make a ruling at this point in time. Because of course, when that motion is made, we will ask the counsel for respondent to make a comment and or reply.
Thank you, Sir Presiding Judge, Justice, Senator Judge. We yield to the wisdom of your decision.
Thank you, ma'am.
With that, we will reserve the right. We are not waiving the right to do call her at the appropriate time and to do file the appropriate request for subpoena ducis tecum and subpoena testificandum. For that, on that matter, Your Honor, I have no further questions and would like to turn over the floor to our lead public prosecutor.
Thank you, Counsel
Your
for
Honor.
Prosecutors, Attorney Lorna Kapunan, for your remarks, which are duly noted. Yes, the lead prosecutor is recognized.
Your Honor, as manifested yesterday, the articles of impeachment is divided into 4 teams, and I would like to turn over to the head prosecutor of Article 4, that is threat, the Honorable Lawrence Defensor. May I request that he be recognized, Your Honor?
The member of the panel of prosecutors, Congressman the Honorable Lawrence Defensor, is recognized for his introduction of Article 4, I presume?
Thank you so much, Mr. Presiding Officer. May I be allowed to make a manifestation to introduce Article 4?
Before you proceed, Senator Judge Cayetano is recognized.
Before that, I ask for your indulgence from the prosecution and the defense. There are certain issues that we are more than willing to listen to the debate here. I'm speaking for myself, but I think for also other senator judges, and of course will give us much leeway. But there are certain issues that we also need time to study. So if we look at our rules of impeachment, suppletory kasi yung rules ng rules of court. And the difference between asking the accused to take the stand and asking someone who's not the accused, but we may say something that is incriminatory. There's a wide difference. So the accused, under the rules of court, hindi mo pwedeng i-force to take the stand. Pero yung hindi accused, they have to take the stand and wait for the question, and then they can claim the right against self-incrimination. But it could be argued that this isn't exactly a criminal court and a criminal offense. It's an impeachment court. So if it pleases the court, or if the prosecution is sure to ask for the subpoena, may I propose, Sir Presiding Officer, that both sides give us a memoranda in advance so that we can also do our part and study rather than spend much more time during the debates, because I'd really like to study that issue also. Thank you, and sorry for the interruption, Congressman.
Noted, Senator Cayetano. However, it is premature at this time. We did with respect to the motion for the issuance of subpoena ad testificandum and ducis tecum in regard to the bank accounts of the spouses Duterte and Carpio, as well as the AMLC records. We require the parties to submit a memoranda, and we will be scheduling it for oral arguments by the parties. If that is the desire of the Honorable Senator Judge Cayetano, we will do the same with respect to this once the motion has been filed formally by the panel of prosecutors. The Honorable Defensor is recognized. You may proceed, sir.
Thank you so much, Your Honor. Honorable Senator Judges, noong 22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan.
Sorry, excuse me.
Your Honor, may I be allowed to finish my manifestation?
I
will not disrespect and interrupt the defense counsel
Yes, but before
once he has started.
this is no disrespect, sir.
Counsel for respondent is recognized.
Thank you, Your Honor. Your Honor, this is improper. The improper for trial. Manifestation, this is not a manifestation proper for court procedure. This is instead them telling a story. This is a narration by the prosecution, which is not allowed. This is not allowed by any rule in any court. So what
May I be allowed
what is
to reply?
proper is that they present their first witness, and
We will be
ready.
presenting our witness, Your Honor. However, please allow us to freely advocate our position.
That's why, Your Honor,
including
we are
the defense
objecting.
when it's their turn. We will not
Counselor
object to the
respondent,
same.
kindly let him finish.
Thank you, Your Honor.
Thank you so much, Your Honor.
To respond to you. Yes, you were saying.
Thank you,
Honorable
Honorable
Defensor.
Senator Judges. Noong ikadalawampu
No,
dalawa ng
Honorable Defensor, Kai, the
Thank you, Your Honor.
objection of
I will
counsel
proceed.
for respondent.
allow us to freely advocate our positions through the proper and respectful discourse. This is not prohibited under the rules. In fact, the court has declared that yesterday, the rules will not comply with the strict procedures of a judicial proceeding. Each article is a separate complaint, and it would be the proper guidance for the senator judges, lalo na po sa ating mga kapwa Pilipino na nanonood, para mas lalo nilang maunawaan ang ipipresenta naming ebidensya. The impeachment is a sui generis. Sui generis dahil kakaiba ito, hindi ito judicial, administrative, o civil o criminal proceeding. Hayaan niyo po kaming magbigyan ng 5 minuto para mailatag namin kung paano namin maipresenta at ang basihan namin sa pagpresenta ng aming ebidensya.
Your Honor, may I respond?
The presiding officer should rule. Although indeed we will interpret the rules liberally, and although indeed this is a sui generis proceeding, neither will we allow any dilatory moves and/or tactics, and I will bind and hold you to your 5 minutes, Honorable Defensor.
Absolutely,
And we
Your
will
Honor.
clock it.
Your Honor,
we will
may-
afford the same opportunity to the counsel for respondents when their turn arrives.
Thank you, Your Honor. May I proceed, Your Honor?
You may proceed.
Honorable Senator Judges, noong ika-22 ng Hunyo 2026, nagulat at nagdalamhati ang buong bansa sa pamamaril sa isang paaralan sa Tacloban City. na ikinasawi ng 3 batang mag-aaral at ikinasugat ng marami pang iba. Ang mga salarin, mga minor de edad, sa kabila ng kanilang murang edad, agad na pumilos ang mga otoridad upang ipatubad ang mga umiiral na batas. Ang mensahe ay malinaw. Ang pagpigiging bata ay hindi nangangahulugang walang pananagutan. Ang pananagutan ay umiiral, pagamat iba ang paraan ng pagpapatupad nito sa ilalim ng batas. Kamakailan, isang pasahero ang inaresto sa airport at kinasuhan matapos itong magbiro na may bomba sa kanyang bagahe dahil mahigpit na ipinapatupad ng mga otoridad ang patakarang zero tolerance policy sa anumang pagbabanggit ng bomba o anumang pampasabog. Sa isang hiwalay na pangyayari noong Mayo 2020, isang public school teacher ang inaresto, pinusasan at kinasuhan ng NBI sa Zambales matapos magbiro na magbibigay ng pabuya sa sinumang papatay sa presidente ng Republika. Ano ang prinsipyo dito? Ang pananagutan ay pinapairal sa lahat, bata man o matanda, nasa laylayan man o nasa katungkulan. The prosecution comes before you today to present evidence for Article 4, establishing that Vice President Sara Zimmerman Duterte committed acts that betrayed the public trust, committed culpable violation of the Constitution, committed high crimes in publicly admitting through a live broadcast that she contracted someone to assassinate the President, the First Lady, and the former House Speaker. Acknowledge the burden of this trial on the senator judges as well as the Filipino people. But it is a duty that we must discharge together, lest the public come to believe that threatening public officials and fostering a culture of impunity are conduct that may be tolerated or condoned, especially coming from the second highest official of the land. Ang mga kilos at salita ng Vice Presidente ay hindi dapat ituring na simpleng krimen sa ilalim ng batas, kundi tuwirang paglabag sa saligang batas. Kaya ang paglilitis na ito ay mahalagang mekanismong itinakda upang tiyakin na ang kapangyarihan ay laging may kaakibat na pananagutan. Accountability must apply to all or none at all. At the heart of this impeachment proceeding lies a fundamental question para sa ating lahat. Can we continue to entrust one of the highest constitutional offices to a public official who, on multiple occasions, purposely and willfully and repeatedly resorted to threats of violence against the very institutions that she swore to uphold and protect? The evidence presented in this article are not just derived from testimonies and authenticated documents, but from the Vice President's own words, own conduct, her very own public admissions. Her words were neither accidental nor taken out of context. They were uttered publicly with the intention to be taken seriously. Huwag kang mag-alala, ma'am, sa security ko kasi may kinausap na ako na tao. At sinabi ko sa kanya na kapag pinatay ako, patayin mo si BBM,
Your Honor.
si Lisa Marcos, si Martin Romualdez. No joke. No joke. What makes especially sinister is that they do not come from an ordinary citizen, but from the Vice President herself, an official who under the Constitution stands to succeed the President. Such carry gravity, freedom of expression, strike the heart of government. This is especially significant given that she has publicly declared her intention to run for president in the next election. What values do we expect from those who occupy the highest office in the land? Delicadeza, palabra de honor, integrity, and loyalty to your oath of office. These are not outdated ideals. They are the foundations of honorable public office. Maraming salamat po, Your Honors.
The remarks of the gentleman are duly noted. However, Chair would like to inform and instruct the Senator judges that the statement and manifestation made by the Honorable Defensor should not in any way be taken as evidentiary because it was merely a manifestation cum introduction of the fourth article of impeachment. Any evidence to be presented proving the fourth article of impeachment should be done through a witness under oath, duly subscribed, and subjected to direct and cross-examination. Call your first witness,
Your
sir.
Honor, may I be allowed also to? Your Honor, we move to strike that opening statement. It's improper for trial. It is not evidentiary in nature. And it only provides conclusions of fact and law. Most of it is irrelevant. And fact of the matter is the prosecution should present evidence and not manifest in this improper manner.
May I be recognized, Your Honor?
No need. Motion is denied. Let it remain in the records and as instructed by the chair for the senator judges not to consider, deem whatever statements were given by the Honorable Defensor as evidentiary in any way, shape, size, or form. Again, counsel, call your first witness.
Your Honor, may I request permission to
Your Honor-
recognize counsel for the panel of prosecutors, Attorney Virgil Ligutan, to conduct the examination of our first witness.
Your
He
Honor,
will
may
be
I-
under the direct
Counsel
suspension and control
correspondent, what is your pleasure?
of
Your
the
Honor,
panel
may
of
I
prosecutors.
register my continuing objection to the opening statement by the prosecution.
Well, I don't think he'll do it again, but nevertheless, so noted.
Thank you, Your
Thank
Honor.
you. Your Honor, may I request that Attorney Virgil Ligutan be recognized to conduct the examination of our first witness.
Counsel for prosecutors, Attorney Virgil Likutan, so that we can have the records clear. Did I pronounce your name correctly, sir?
Your Honors, magandang hapon. My full name is Attorney Armando Virgil Discartin Ligutan, Your Honor, please.
And you've entered your appearance yesterday,
Yes,
counsel?
Your Honor. Duly entered my appearance as one of the counsel for the prosecution.
You may proceed, sir. Call your
Thank
first
you
witness.
Thank you so much. Mga kababayan, we call to the witness stand the first witness for the prosecution in the person of NBI Senior Agent Jean-Marc Santa Ana Calilo.
Kindly bring the witness to the witness stand. Please remain standing. Clerk of court is instructed to kindly administer the oath to the witness.
Please raise your right hand. You, John Mark Calilong,
I, John Mark Calilong,
do swear
who swear
that the evidence you shall give
that evidence that I'll give
in the case now pending
is in the case now pending
between the Philippines
in the Philippines
and Vice President Sara Zimmerman Duterte
and Vice President Sara Zimmerman Duterte
shall be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the
So
truth.
help me God.
So help me God.
Your witness, counsel.
Thank you so much, Your Honors. Your Honors, mga kababayan, the testimony of the first witness for the prosecution, NBI Senior Agent John Mark Santa Ana Calilo, is offered to prove the following. Number one, si Agent John Mark Calilong ay isang senior agent of the National Bureau of Investigation. Number two, he is well-trained and experienced in the field of digital forensic examination, having undergone extensive training in the field, making him competent in identifying, preserving, collecting, and authenticating digital evidence. Pangatlo, si Agent Kalilong ay bahagi ng NBI Cybercrime Division Team na inatasang mag-imbestiga sa mga pahayag at pagbabanta ng Vice Presidente laban sa Pangulo ng Pilipinas Unang Ginang at dating Speaker ng House of Representatives sa isang online media briefing noong Nobyembre 23, taong 2024. Pang-apat, partikular na sinabi sa publiko ng Vice Presidente na may kinontrata na siyang tao na papatay sa Pangulo, Unang Ginang at former Speaker ng House of Representatives. At ito ay nakatatak na sa kasaysayan ng ating bansa bilang unang pagkakataon na ang isang Vice Presidente ay nakipagkontrata sa isang mamamatay tao upang patayin no less than the President of the Republic of the Philippines. Panglima.
Your Honor, may I object. Is this a speech or an offer?
Your Honor, please, with all due respect to counsel,
For the prosecutor may proceed.
it should not be a
May I register my continuing
There's
objection?
no proper ground. This is offer of testimony. Please hold your horses. Number 5, the public statements and threats of the Vice President were publicly live streamed and captured on video. Number 6, Agent Kalilong is a designated agent on case for the investigation. Number 7, as agents on case, Agent Kalilong personally conducted and participated in the cybercrime and open source investigation relating to the subject video and related digital recordings. Pangwalo, sa takbo ng open source investigation na pag-alaman ng NBI na ang Vice Presidente ay nagpahayag din ng iba pang kahawig na pananakot sa buhay ng Pangulo. Kasama na ang sinabi niya sa publiko na minsan naisip niyang hugutan ng ang Pangulo ng Republika ng Pilipinas. Number 9, in the course of the investigation, Agent Kalilong duly identified, preserved, collected, and authenticated the subject video and other related digital recordings. And number 10, the last offer of testimony, Your Honors, Agent Kalilong will testify on such other matters as may be relevant, material, incidental to the issues involved in this impeachment proceeding, and will identify relevant and material documentary and object pieces of evidence. That is the offer of testimony of our first witness, Your Honor, please.
Presiding officer will now hear the objection and or comments, if any, of the counsel for respondent to the offer
Prior to
made by counsel for the prosecution.
Your Honor, may we move for the exclusion of Agent Kalilong for being not previously attached to the Saballa and Cabrera complaints, as well as exclusion on the ground that he was not included in the articles of impeachment transmitted to the Senate Impeachment Court.
Can I respond to that, Your Honor, please?
Counsel for prosecutor may do so.
Mga kababayan, in this stage of the proceedings, the prosecution is about to present a witness, and the defense is invoking the fact that this witness is not listed as one of the witnesses in the Saballa complaint. The Saballa complaint already lived its natural life. Your Honor, This is the impeachment proceeding of the articles of impeachment filed by the House of Representatives. Sabale et al. Is done. That should not be a proper objection, Your Honor, please. As to the number 2, I think the good counsel mentioned that it is not part, this witness is not part of the articles of impeachment. Your Honor, please, I have been practicing for quite some time. I don't see that.
Your Honor, may I allow to reply also?
Can I finish? It's not a ground. And in fact, Your Honor, please, to settle the matter, this witness is listed in the pretrial order. The issue is settled. The issue is passé. No ground for objection. Let me proceed, Your Honor.
Of course not, Your Honor. There were no rulings.
Counsel for respondent is recognized
Thank you,
for
Your
a
Honor.
final rebuttal on this issue before the court will, before the chair will issue a ruling.
Your Honor, there were no rulings on the pretrial order on exclusion of witnesses. We have a current petition with the Supreme Court questioning the very actions of the prosecution to allow the presentation of evidence that were not attached to the Sabaya or Cabrera impeachment complaints would allow the House of Representatives and the prosecution to circumvent the very procedural abuse condemned in Stonehill versus Jokno and allow the violation of the respondent's constitutional rights as held in Duterte in the House of, versus the House of Representatives. Your Honor, the prosecution says the Sabaya complaints have lived their and they died their natural deaths. However, Your Honor, this precisely does not cure what the prosecution did. This does not cure the violation of the rights of my client.
If I may, Your Honor, please.
The chair will make its ruling. The motion to exclude by the counsel for respondent is hereby denied. Chair cites Enrile versus Sandigan Bayan, which states that the prosecutors may add or rely on evidence during pretrial, even if the evidence is not stated in the complaint or articles, because only a summary is required to be stated in the articles of impeachment, in this case, and or complaint, and not a complete list of the prosecution's evidence and or witnesses. The court in general will not shackle the prosecution by limiting it to the evidence mentioned in the information and or the articles, especially when it is mentioned in the pre-trial brief, not only order but brief, of the counsel for prosecutors. But in relation to this witness, even if you will do cross, you can register your continuing objection, counsel for respondent.
We are registering it, Your Honor, please.
So noted.